Panel will talk about practical implications going forward. And our chair is Sareta Ashraph. She is a barrister specialized in international criminal law and international humanitarian law. She has an extensive experience working as legal analyst and legal advisor in a variety of accountability mechanisms. Until August 2019, she was based in Iraq, acting as a senior analyst at the United Nations investigative team to promote accountability for crimes committed by Daesh. She is an associate member of Garden Court Chambers. Sareta, the floor is yours.
Thank you, and thank you for having us. I'm joined by a panel of experts here with me. I'm not going to go through all their bios because they're quite extensive and we are limited on time. But just to say that obviously I'm joined by Wayne Jordash to my right, who is a world-leading expert on international humanitarian law, international human rights law, and international criminal law, regularly advising governments, including Ukraine, Bangladesh, Libya, Serbia, and Vietnam. To his right, you have Dr. Myriam Roccatello, who is the Deputy Executive Director and Director of Programs at the ICTJ. To my immediate left, Professor Alette Smeulers, if I pronounce that right, who is a Professor of Criminal Law and Criminology of International Crimes at the Law Faculty at the University of Groningen and the University College Groningen. And to her left, Professor Cécile Aptel, who is currently the Director of Policy, Strategy and Knowledge at the International Federation of the Red Cross and Red Crescent Society, where she manages international humanitarian programs. Their bios are more extensive, but they are in your the day's leaflet, so I want to continue on with the panel, which we're going to be ending fairly promptly today. It's the last panel of the day, and I want to thank everyone who's here. I'm going to inject a bit of a Caribbean flavor into the panel by making it quite informal and hopefully some rigorous discussions and leaving quite a lot of time for questions insofar as we're able, but not being very Caribbean in that we will be ending promptly at 4:45 p.m. today. I'm feeling particularly comfortable because I have a lot of experience sitting to the left of Wayne Jordash in a courtroom. So I'm hoping that it's an enjoyable panel for everyone in the room. Over the past 10 years, there has been a dramatic shift in the willingness of bodies within the United Nations, among them the Human Rights Council, the General Assembly, and the Security Council, to direct and increasingly to establish entities to investigate, analyze, preserve, and engage in case building in situations where war crimes, crimes against humanity, and genocide are alleged to be taking place. In December 2016, a new generation of specifically mandated entities was born, with the General Assembly's establishment of the Syria Mechanism, also known as the IIIM. This was swiftly established, swiftly followed by the Security Council in its Resolution 2379, which set up UNITAD, the United Nations Investigative Team, to promote accountability for crimes committed by Daesh. And most recently, in September 2019, the UN Human Rights Council established the International Independent Mechanism for Myanmar. The establishment of these entities, which are not prosecutorial in nature, but rather are aspirationally linked to accountability, drawing upon Ambassador Rapp's phrasing earlier yesterday in the program of if we build the cases, they will come, arise in the context, and I would say are the result of the blocked path to accountability to justice at an international level, notably through the International Criminal Court. Flowing from a natural desire to find any space within which to advance justice, we see now the importance of national trials to the international criminal justice experiment deepening. Indeed, for Syria and Iraq, in which I've worked for the last 5 years, the sparks of accountability are most likely to find their fuel in the tinderboxes of the domestic courts. This panel this afternoon is looking at the practical implications going forward, looking at the lessons to be learned from the existing accountability mechanisms. What works, and who does it work for exactly? What are the challenges, and are there any plausible solutions? How can systems of international criminal law ensure accountability for new and emerging forms of criminality? And when we leave this conference, are we leaving it as optimists or pessimists? So these are some of the questions that we'll be looking at today. And I'm going to start first with Cécile. Cécile, given that you headed the IIIM startup team and have been directly involved in the establishment of a number of commissions of inquiry and UN fact-finding missions, and even prior to that with the ICTR, the Bosnia State Court, and the STL, can you clarify how you think these two generations differ in their objectives?
Thank you.
And building on that, do you see the vision for accountability of the later generation of entities, such as the IIIM and the IIM, being met by the reality?
Thank you very much, Sareta, and thank you very, very much to the Academy for inviting me, and also for putting such a high level of discussion and exchange over the last 2 days. I think, Sareta, that you're really right. We can speak of different generations. And I think it will be really wrong to amalgamate what we have seen more recently taking the form of the mechanism, the investigative mechanisms, as you said, Syria, Myanmar, Iraq, to make them equivalent or treat them the same way that we can really of the courts that are really courts. So on the one hand, we've had generations of fully fledged courts with all of what it means in terms of having judges to start with, and courts and trials and prosecutions and defense. And on the other hand, what we have are investigative mechanisms that sometimes don't even have a full investigative mandate. And I'll maybe come back to that. So we can't really just look at courts and put them, or look at those new mandates and deal with them and assess them like we will do of courts. The mandate is to, and I cite, collect, consolidate, preserve, and analyze evidence. At least that's the mandate of the IIIM for Syria and the IIM for Myanmar. So to collect, consolidate, preserve, and analyze evidence, and it goes on, and to prepare files in order to facilitate and expedite criminal proceedings in national, regional, or international courts or tribunals that may have jurisdiction. So really opening up a large array of places where those cases may, and I insist it says may be tried. So we really have, or that may have jurisdiction. It's even a question of whether they have a jurisdiction to deal with these crimes. So we really can't compare the generation of establishment of courts with clear mandate, and that usually even had primacy over national courts. And that's an argument that I think is also important to bring in the discussion. We've been discussing since this morning of those various international tribunals. Some of them, like the ICTY and ICTR, had a clear primacy over national jurisdictions, which is also the way then we should assess their relationship with courts such as the war crime chambers in the court of Bosnia-Herzegovina that Toby Cadman referred to this morning, because they had primacy, and therefore the relationship with any domestic courts was one of having primacy while having concurrent jurisdiction. And now we really look at places that are much more sources of information for courts, and again, national, regional, or really domestic court. It's much more sources of information and evidence that they're supposed to really prepare files. I think it's also really important that we keep in mind that basically they are, in a context where we see a lot of impunity, they are just supposed to be beacon for the future. Places where we give criminal accountability a chance for the future by preserving information now and organizing files. So they're not criminal accountability mechanisms, they are mechanisms to collect information, analyze it, prepare files that may or may not lead to criminal accountability.
And can I ask you, you've spoken about giving a criminal accountability a chance for the future. I've worked a lot, for example, with the Yazidi community, and what we've seen there is the enthusiasm for these new forms of as I said, aspirationally linked to accountability, these mechanisms which seek to give accountability a chance. There's more, and I personally feel more enthusiasm at the level of the international lawyers than necessarily at the grass level. I was wondering if you could speak about whether you felt like the vision for accountability is being shared equally among all those who will hopefully participate in it.
It's a very good point. I mean, it really, any assessment as to whether the vision has been realized, which was what you were also mentioning earlier, has to be seen asking whose vision, who is speaking, who is assessing them. So I think that I mean, if I assess them as myself, as someone who was directly involved in asked to actually prepare the terms of reference of the first IIIM for Syria, it may be very interesting that in retrospect it seems easy and now we just assume that those mechanisms are there. In fact, I was really puzzled by something that Ambassador Schäfer mentioned yesterday, and I think that was also Serge Bravertz, how in retrospect we can see this court as being obvious. At the time when they were established and their statutes were adopted, that was not so obvious. Similarly, when the General Assembly adopted a 3-page resolution in December 2016, there was really no hope, and in fact not even expectation, I think, that resolution would be turned into something more than a 3-page resolution by the General Assembly, especially concerning Syria, with the context that we know, not only the context of very serious allegations being repeatedly committed over an extended period of time, but also one situation that had been dividing the Security Council for a really long time. So when in fact that resolution was adopted, it was a real challenge to turn it from 3 pages into reality, which really the vision at that time was simply establishing it, making sure that it will have a budget, a place where to work, and that was really a challenge, but more importantly, that it will be a credible, really professional mechanism with a reputation, and I think that has really been achieved, that would also include the Syrian civil society, and we really went out of our ways to really just ensure that the Syrian civil society, who was not in favor of it initially, was progressively consulted and brought in. But also, the vision that at least I had was that we should create a mechanism that will be making the most of information technology and digital, and really move investigation into the 21st century. Because obviously, first, we have many more means now that we had when the ad hoc tribunals or the other special courts were established, but also, and very importantly, most Syrian persons have this in their pocket, irrespective of their age and gender. And once you have that, you can so immediately take photographs as crimes are ongoing. Every citizen becomes a possible investigator, or at least taking the information. And in the context of Syria, I think that we've seen the first situation of a huge amount of digital information that can potentially be digital evidence being collected, but not only collected, placed on social media. The number of videos, photographs readily available on social media is there, and we really felt that it was important that the mechanism would also collect all of that and analyze it. Now, your question is that sufficient, and shouldn't we really look much more at the expectations of victims and survivors? And on this, and in fact, I've been discussing with some of you, I have, in my current job, working in humanitarian affairs, I spend a lot of time on the ground in really places where we see a lot of, really difficult situations. And I was just a few weeks back in Cox's Bazar, in the camps where there are many people, Rohingyas, that have fled Myanmar. And I was really, I really struggled because I met a number of women, very often very young women, that had been victims of rape and other sexual and gender-based violence, but in fact rapes. And one of them was telling me her story with no expectations of accountability, because that's not what I was there for in any case. But she was really recounting to me several rapes committed in different contexts. And that, of course, included rapes committed very much in the context of the atrocities and very much involving state actors, but also a whole history of domestic violence before she really left Myanmar, and then also now being raped regularly by neighbors in the camps. And I then, taking my international criminal lawyer sort of hat on, I was just thinking how we fail victims by working with crimes in silos. She has been raped, let's say, 5 times, and one of these rapes may amount to war crime or crimes against humanity or genocide, and we're going to really look at building criminal accountability around that one rape. It may be 1 out of 5, and the 4 others will completely fall off our radar, and we're not going to actually even conceive of it when, in fact, in terms of the impact on her, it's not that one that makes any difference because of the identity of the perpetrators or the context. It may, but very often it doesn't. And what really matters to her is, in fact, guarantees of non-recurrence. It's making sure that she is as safe as she can so that tomorrow in the camp, she's not going to be raped again. So I think that's really also I wanted to really bring that story here because I think that it's also those stories and those visions and understanding from victims that we also need to bear in mind.
Thank you. And we just want to turn to Wayne, actually, because you're mentioning your time in Cox's Bazar with the Rohingya community. And I know that Wayne, through his organization Global Rights Compliance, has been doing a fair amount of work with that community as well. And I do want to dedicate some of the time of this conference to speaking about, when we talk about practical implications going forward, what are the practical implications for the survivor communities and civil society in general, because their metrics of success may be very different from the metrics of success of many of us in the room. So what are your view of the practical implications of these new accountability mechanisms for survivor communities and civil society more generally?
Thank you. Thank you to the Academy for the invitation. It's been a great 2 days. I really appreciate being here. As to the question and the time of day, I'm afraid my experience working with a group of 400 Rohingya has left me somewhat pessimistic about these new mechanisms and about international justice as a whole. I'm pessimistic because the options for real accountability are embarrassingly scant. And I'm pessimistic because I'm not sure that the international criminal community has appreciated that fully yet. And I think appreciating it is an opportunity to then try to work out a longer-term strategy in terms of how to confront the obvious, which is that for the next few years, perhaps a generation, the opportunity for criminal convictions, criminal accountability is going to be pretty slim. Looking at, for example, the Rohingya, when I visited the Cox's Bazar, I was struck by two things: the massiveness and insuperable nature of the crimes and the justice prospects for the Rohingya, and actually the failure of the international relief effort to contribute to anything more than the immediate needs of that refugee community. Just taking one for the moment, as I say, the prospects for accountability for the Rohingya are embarrassingly scant. There's the ongoing ICC proceedings, which, if we're lucky, will have a full investigation begin next year. And if we're lucky, a small team of investigators will go to Cox's Bazar and try to take statements from 700,000 or a select few of 700,000 victims. We have the UN independent fact-finding mission, which has done great advocacy, in fact, not only identifying core international crimes that have been committed or likely to have been committed, but actually going one step further and identifying likely suspects and critical linkage evidence. But it is, at the end of the day, an advocacy tool. And then we have the IIMM, which I'll come back to in a minute, and we have the possibility of prosecutions under universal jurisdiction and a potential case at the ICJ for genocide. And on that note, it looks as though Gambia is about to step up to the mark, which is a brave and worthwhile step, and they should be applauded for it. But as regards the IIMM, I think we should be very cautious in terms of what we expect from it. It is necessary, there's no doubt about it, but it is, at the end of the day, a sign of international justice failure. And I think we should be honest about that. And I think we should be honest about what it is going to be able to achieve. How much evidence can it collect or collate? What will the quality of that evidence be? And what will happen to it? These are three very important questions to ask. There are 1 million refugees in that camp, all of them with serious trauma and capacity issues with urgent humanitarian concerns, many of which are not being met. Little or no education and have been abused, marginalized for perhaps decades. At best, a team of investigators will emerge from the IIM sometime in the next year and find their way to Cox's Bazar and do their very best to collate evidence in these circumstances. I'd say this, having worked on many conflicts over the last few years, the Special Court for Sierra Leone, the ICTR, the ECCC and so on, the capacity of the Rohingya is as low as I've seen in terms of education, in terms of ability to access these types of mechanisms, and ability to be able to describe in detail precisely what happened. And we're talking about investigators arriving maybe 2, maybe 3, maybe 4 years after these events, when many of those accounts have been shared on many different occasions, if not with each other, then also with international journalists and human rights organizations, shared in ways which does not necessarily protect the integrity of that information. In sum, taking statements is going to be extremely difficult. Identifying crimes and perpetrators is going to be extremely difficult. What to do with that evidence is even more difficult. The Rohingya, I beg your pardon, the military do not travel. They're not going to turn up in Germany. They're not going to turn up in Western Europe. They hide their money in Singapore and likewise. They are not going to be easy to bring to account. The head of the IIM is a very talented lawyer, Nick Cumjon, and he will be undoubtedly dedicated and be innovative in his approach. But we have to be realistic. He may use that evidence to support sanctions, but again, what is that going to really do in the long run when the money is hidden in Singapore and other impenetrable financial areas, and when the military do not want to travel anyway? If our hope lies in Aung San Suu Kyi, then I think we all know there's not much hope in that respect either. So I hate to be pessimistic, but I am pessimistic. And what do the Rohingya think about the IIM? I'm actually not sure that anyone's asked them yet. We know what the diaspora think about it. The diaspora do, I think, support it generally. That's my information. But actually, 1 million Rohingyas are sitting in Cox's Bazar and barely anyone is talking to them about international justice. So I'm not sure they've expressed a view or even been asked whether they support that as a mechanism.
Well, I think those comments are going to get a lot of hands raised when I ask for questions later. I have to say I share some of that pessimism. There's actually a study coming out, an article coming out, which is based on the interview of over 1,000 Yazidis in IDP camps in the Kurdistan region of Iraq, which is also lending the idea of what is justice, what does justice mean to them? And that's not a question that is actually often asked. And I think the results of those studies, once it's been published, will be quite different to some of the discussions we've been having about international justice. That doesn't render international justice without value, of course, particularly for communities who've never seen a level of accountability for any crimes committed prior. But nevertheless, I think it calls into question who does these systems work for. Can I just ask, because Cécile raised the issue of basically a gap between expectations, between what these entities are promising in terms of a chance at accountability, versus the gap between the reality of what they may actually deliver, which I don't know. I think the question is that gap being communicated to the people on the ground? And how do you think that you could embed the civil society participation in the process a bit better, given that it seems to be coming from, I suppose, kind of an elite discourse, either in New York or Geneva, coming down? How do we embed the civil society participation better? And I'll ask Wayne, but then obviously I'll open that up to the panel afterwards.
Okay. I'll be brief because I spoke for quite a long time. I think it's indicative or illustrative of the fact that when the prosecution filed an application, as courageous and clever application to seeking jurisdiction or a finding of jurisdiction at the pre-trial chamber in relation to deportation, 2 victim groups only filed submissions. That was the victims that I represented and 1 other group. So in total, 40, I think, 400 one group and 40 in the other. And I think that gives an indication of the lack of victim participation and the lack of access that they have to international justice mechanisms, that you have so few out of so many participating in such a critical application. And like I said a moment ago, I am not convinced that there is anything other than a handful of Bangladeshi human rights organizations doing their best to raise these issues, a handful of international organizations doing their best to raise these issues in the camp. Most, I am fairly convinced, therefore, will not have access to information about these mechanisms. At the very least, what they need is, in my view, 1, legal counseling about the availability of international justice mechanisms, 2, information about the work of the ICC, UN fact-finding mission, and so on, 3, advice on how individual complaints can be made, 4, advice training on how to document crimes, psychosocial support and legal support and empowerment, and a referral to appropriate services in relation to their legal right. None of that is happening in any systematic way for the million victims who sit in Cox's Bazar.
Just extremely briefly to just try to really bring the reality of this victim that I was describing earlier, and she's one among many tens of thousands. I mean, a population of 700,000 in the camps, and in fact, she's and what her expectations are. And I mean, in the case of that actual person, her expectations and her hope was security. Just give me security so that I'm not raped again tomorrow. And I would imagine that if that person will be slightly older, it will be so that I am not raped and my daughters are not raped. So that security and a guarantee, which in legal terms we will call guarantees of non-recurrence, is the minimum level of accountability. And that at least we sort of can assume that people do want. When victims don't have that, I think that any other layers of justice, so to speak, that may go all the way to collecting the evidence pertaining to the crimes that they may have suffered, all the way to holding those responsible into account, are almost dreams that seem a bit unreal to them. And that begs another question, which I would like to rhetorically ask, but which has been often in my mind in those contexts, which is, who is responsible for creating expectations for some forms of accountability and then not delivering it? Because we also need to face that difficult moral dilemma, which is when then there is a lot of information around forms of accountabilities or accountability being promised or expectations being built and then no delivery.
Thank you. I think this is something we'll probably return to again in the course of the panel and the questions, but I want to turn the moment to Alette. Your research focuses on these types of crimes, the perpetrators and their criminal prosecution, the causes of these types of crimes. And you've written about how mass atrocity crimes are committed in a social context in which violence is justified and legitimized. And of course, we've seen that time and again. We've seen it in the Holocaust, in Rwanda, and also more recently in relation to ISIS, and also the intelligence and security apparatus of the Syrian state. And I want to focus particularly on your research on perpetrators, because there is a tendency to other perpetrators of crimes, to see them somehow as not ordinary people, that they're often, language is employed that they are monsters, what they're doing is bestial, they are somehow removing, by committing these crimes, they have removed themselves from the community of ordinary people. And yet, although that is the impulse which seems to come up time and time again for every conflict in which defense lawyers try and combat in the courtroom, actually what we see time and time again, and what history has shown us, is that very ordinary people commit these crimes, and they commit them for a wide range of reasons. And I think those reasons actually differ quite a lot depending on where they are in the effective hierarchy of the entity which is committing the crimes. And I was wondering, given your research on both the causes of crimes and what motivates perpetrators of mass atrocity crimes, do you think these new accountability mechanisms are too blunt an instrument to understand why and how the crimes are committed?
Thanks for the question and also the invitation of speaking here. Yes, I think what is good about international criminal justice is to focus on individuals, as was said in this course, that crimes are committed by men, not by abstract entities. However, in order to understand why they commit the crimes, we have to look at the context. And I think it doesn't make much sense to portray the suspects and the defendants as monsters. That wouldn't help. And also merely locking them up might be justified, but doesn't solve the problem, because new people in new typical kind of situations could emerge and commit similar crimes. So as you indeed said, most perpetrator research has shown that, are ordinary people who commit these crimes in extraordinary circumstances. They are not born criminals, they are transformed from ordinary people into perpetrators. So I think it's very important to take that into account and to look at the context in which they operate. Because perpetrators of international crimes, they believe that they do the right thing, that what they do is condoned and acceptable. And they believe sometimes even it's their duty to rape, kill, maim, and torture. And I think we should really distinguish between types of perpetrators and role of perpetrators, whether they merely operate in a specific context or whether they create that context. Now, certainly do not misunderstand me saying that the perpetrators who operate in a context are merely automatons, because they're not. They still might have ulterior motives, but the fact that they commit their crimes in a context that condones what they're doing by a state who's believing it is acceptable what they're doing, plays a huge and very important role, because many of them, before the period of mass violence, were law-abiding citizens. And we could qualify them as law-abiding criminals, which seems a contradictio in terminus, but I think it explains what these people are. And then, yes, they're driven by different motives, but it is the crimes they commit are usually crimes of obedience, which is quite a different nature compared to ordinary crimes, which are crimes of defiance. So I think we should really look at the roles of perpetrators in creating this context, making others believe that what they're doing is right, is a duty, and is acceptable. So we should look at the ones who control this context.
In my work on ISIS and the Yazidis, we saw that quite clearly, that they instrumentalized already existing social fissures and existing marginalizations, so that people were already more tolerant of violence perhaps towards that group. And then it became entrenched as looking back at almost a fantasy of previous glory, as is often the case, for example, as you saw in Nazi Germany and with the Hutu power movement. But then in these new range of accountability mechanisms which are developing, which are in some ways slightly freed from the narrowness and not necessarily time frame, the narrowness of a prosecution investigation, which kind of will select specific incidents and then drill down. They're so far pre-prosecutorial that there is more room for them to have a wide-ranging look at perpetrators. And I was wondering, how would you like to see these accountability mechanisms that we're discussing develop to better capture the range of liability within the perpetrator community?
Okay, what I think is that our current international criminal justice system is very much based on national criminal justice systems, in the sense that they focus on the individual. And in a way that is necessary, but looking at there are people committing these crimes in this specific context. And if you look at how to create accountability, we're looking very much as whether they're ordering, inciting, instigating. And I think we should look more at more distant ways of ensuring these crimes. So I very much believe that the control theory, which is used by the ICC, is helpful, but there they still have very high threshold before someone can be found liable under this theory. So I think we really need to distinguish these perpetrators and accept that those who create this context in which the ideology, because ideology always plays an important role, but whatever it is, right-wing, left-wing, religious, kind of makes the perpetrators believe that they're entitled to the right to rape, kill, maim, and torture, that it's fine to do so. So I think creating that context doesn't right now fall under the control theory, but I think it should be there, because this context is all crucial. And also we need to understand these mechanisms better. So within law, the focus is always on the individual, which is good, but if you look at social psychological research on understanding the behavior, it is known that situational factors play a far bigger role usually than the dispositional factors. And I'm not saying that to excuse the perpetrators, but I'm saying that to focus on the situational factors and to make sure that we also understand the interaction and the people who are responsible for creating that situation. So I think our accountability mechanism should move there and also should focus on these questions, because that will be better in the light of prevention, to understand that mechanism better.
That's interesting. I think, again, more questions will arise in the second portion. I want to ask us the question to actually anyone in the panel, maybe multiple people on the panel, because I think, again, I think the philosophical underpinning of a lot of these entities, be it UNITAD, the IIM, and the IIM and the IIIM, is this idea of you build a case and they will come. But I think there's something that we don't actually acknowledge very easily when it comes to that underlying philosophy, which is that a lot of the ideas are based upon tremendous crimes have happened, there is no path to justice anywhere else, something has to be done, and this is something. But the case will only come when you have a link to an accused. If you can find a link to an alleged perpetrator where there's grounds for trying that person, leaving aside trying to locate the person you're trying, which is a more pragmatic difficulty. And I'm wondering now if we have really properly considered the challenges to groups like the IIM and UNITAD in particular, and the IIIM, in fact, are they hindered in tracing linkage up the effective command? Because inherently they lack the resources that might incentivize and protect insiders to speak out. I personally don't know of a case that you've got beyond mid-level of a effective command structure without being able to flip someone on the inside to give you insight into what the difference between the de jure and effective command structure is. So when we're speaking about actually how we're explaining what this promise of accountability, do we think that there's a potential problem in regards to how these entities are able to follow up the chain of command beyond, the level of a particular detention center, for example? I kind of silenced all of you.
No, go ahead.
I think that it's not exclusive to these mechanisms. It's really one of the essential challenges for these types of investigations and prosecution as well. And I think that the mechanisms are as equipped as are the ad hoc tribunals or the ICC, to the extent that they can do what has become known as structural investigations. And so they're not precluded to do structural investigation, and they're not precluded to even prepare structural files. I mean, there is nothing, at least in the terms of reference of the IIIM and the IIM, sorry to use those really difficult terms, but so Syria and Myanmar, they can prepare those structural files. That's not necessarily the response to everything, but I don't think it's new with this mechanism. I think it's really something that we face throughout, in fact, those complex crimes.
Sorry, go ahead.
Well, I think it's an important question, and I think it's a question about what is the function of these mechanisms. I mean, if you look at their mandates, it's clear that they're going to collate information, and it's clear that, at least with the Myanmar one, it looks as though they have sufficient room to investigate themselves. For what purposes is something that perhaps we need to think about. Finding linkage evidence, building up the chain is, as any prosecutor knows, very, very difficult, and I doubt, in the case of Myanmar at least, that linkage upwards is going to be very easy to establish, and it may in fact not be possible given that most of the evidence is going to be crime-based. It's going to be villagers driven out of their homes, and as I understand it, Human Rights Watch, for example, has a list of about 150 direct perpetrators, but as I understand it, no other organizations are not able to get any higher than that. And to be frank, there's probably not much prospect that the IIMM is able to go much higher, because they're going to be limited in the same way by the lack of evidence, which then raises another question. Well, perhaps what it should be thinking about doing is what the international tribunals always said, at least initially, that they were going to do, which was to write history and maybe tell us a story, and maybe that's what the mechanisms can do, because perhaps that's a function of the mechanisms, is to keep up the pressure on the regime, on the alleged perpetrators, and tell a story as far as they can. And I think that's a really legitimate and interesting role that these mechanisms might be able to play.
Yeah. For myself, I still actually wonder how a mechanism that can't offer anything to someone at a low rank in terms of protection from prosecution or relocation or, or protection from people who they may currently be imprisoned with, how it operates to get those people to speak about who's higher up. But anyway, I want to continue on because we have a quite short session, and I do want to leave some time for questions. So turning now to Anna Myriam, you've spoken about, we've been speaking in the last couple of days, as I'm sure many of you have in the room, about some of the topics that have been addressed. And one of the things that you've spoken about to me has been the importance of the individual crimes not obscuring the often entrenched structural injustices in society in which mass atrocities occur. And actually that has links also with your work, Alette, which is looking at how people slowly move towards becoming perpetrators over time, not simply at the moment in which the crime occurs. So looking at how entrenched structural justices form part of understanding how mass atrocity occurs. And so my question for you is, as criminal accountability continues to evolve, should we also be recording and preserving evidence of more systemic injustices which underpin mass atrocity crimes?
Yes, thank you very much for this question. I was really looking forward. And thank you so much for having me here. As you can imagine, because of my capacity, I bring a little bit of a different lens to the debate on criminal accountability, both international, domestic, or any other level we can pursue. I started my career in the UN trying to prosecute international crimes in Kosovo rather poorly, I must admit. And as I went on and I got involved in other attempts and initiatives, I came to realize that what we are all collectively doing here cannot necessarily achieve the traditional goal of criminal accountability or criminal justice, which are retribution, punishment, and deterrence. And I am leaning towards a different concept, which is the concept of persuasion. So we are trying to persuade a context, a society, a collective, which is differently organized, but generally is a state, that a certain culture, a violent culture, or an exclusion culture, discrimination, and other forms of exclusions that bring abuses and inevitably gross violation of human rights and humanitarian law that amount to international crimes must be expunged from that context. So it's absolutely critical that we operate at multiple levels in order to understand the whys and hows that culture was not only established, but allowed to prosper. And therefore, of course, it would be very important for me that whatever mechanism we use, we consider it in its complementarity, in what it can contribute to the ultimate goal, and operate a variety of different processes that provide acknowledgement, a narrative that challenges the legitimization or the being convinced that what is being done is legitimate, justifiable, and pursue a higher goal, and slowly, therefore, eliminate that behavior and those beliefs. So the understanding of how this was made possible and the different roles, the different actors, internationals, corporations, international governments, and so on, as well as obviously the domestic context have in all of this is paramount. And because of the limitations that this new generation of mechanisms have, the innovative use of what they collect, how they collect and reach out to victims, and the trying to make the process as participatory as possible, including with truth-seeking and other reparation processes and so on, becomes all part of a mosaic that I think it's the only chance in the very long term to achieve that ultimate goal.
So then you think the practical implications going forward as we, in this new generation of accountability-based entities, do you think then there needs to be some thought about how they need to work in tandem with broader transitional justice?
Yes, definitely. With these, however, if we're talking about the Syria, Myanmar, and UNITAD, my concern primarily is how they are going to interact with possible additional transitional justice mechanisms. Because one fundamental element of giving back dignity and recognition to victims is the aspect of a formal, maybe non-judicial, but formal and solemn proceeding that provides that backing, that support that the victims, it's their turn now to provide a narrative that was denied, challenged, demonized before. And these, at this point in time, I'm a bit unclear how specifically the Myanmar mechanism can be linked to a transitional justice other measure that provides that element of solemnity and formality, to be honest. I don't want to underestimate the great contribution that civil society initiatives of truth-seeking or others have brought to advancement, the advancement of accountability. I mean, we all know, for example, in Guatemala, everything started with, the Catholic Church initiating a truth-seeking exercise. However, because of the limitations we are working with, a large group of victims that even in the context we work on seems to distinguish itself for its marginalization, for its, the devastating conditions they come from, they lived, and they continue to face. I'm not sure how we can provide something that is meaningful.
Thank you. Cécile, I'm just going to throw quickly back to you because I want to leave about 25 minutes for questions at the end, 25 minutes. I want to return to something that you raised earlier, which is to note that the mandates of these bodies are not only about investigating and analyzing, they're also very fundamentally about preserving evidence, information and evidence. And the suggestion of a permanent investigative unit, or a permanent investigative mechanism has been raised, but I think within this room and more generally it's been accepted that politically it's unlikely a body will be created with an unspecified mandate to investigate whatever the head feels like she or he wants to investigate. But given the importance of the preservation of information and evidence, do you think that there is, given that importance, but also given the investment that has been made in increasing the capacity of civil society to document and record crimes, either through Eyewitness App or through IICI trainings or various other trainings for which there seems to be a serious amount of funding, do you see a role for example, a permanent preservation unit within the UN? So you take out the idea of worrying that people are going to open investigations wherever they want, but you have a body within the UN that is capable, for example, of collecting information from civil society, including in places where the chances of accountability are very, very narrow given the geopolitical realities.
Thank you, Sareta. That's a really tough set of questions there, especially before such an audience. I think that certainly, so we need to be mindful, maybe there are different ways of answering your question. What will be ideal, and then what is politically feasible? So, and what already exists. So what already exists is, in fact, that whenever there are commissions of inquiry or fact-finding missions under UN auspices, the results of what they do, which may include not only the public reports, but also, I mean, some of them are mandated to prepare lists of alleged perpetrators. These are actually kept by the UN entities responsible for this, so mostly the Office of the High Commissioner for Human Rights, and they are preserved. And what is really important to note is that because this OHCHR is part of the United Nations, they're preserved under United Nations privileges and immunities. So it's not that anyone can have access to them, but it is that they are available. So they can be requested by competent judicial authorities, for instance, and there have been. I mean, some of the cases even that were referred in the panel before on universal jurisdictions were or involved asking the UN, having the prosecutors or the war crimes unit request the UN for some of the information. So there is already something that exists. So we're not really completely, having no preservation. But of course, we only preserve where there is a mandate, yes? So the big question is that there are a lot of gaps where there are no fact-finding or commissions of inquiry. And there the ideal will be, yes, indeed, it will be, much better for the sake of promoting criminal accountability to have one permanent global investigation mechanism. But then I don't actually think that it's politically realistic, and I'm not even sure that there are many challenges with that. What may be politically feasible is to really create a space where there can be more systematic use first of the same methodology, so even economies being made by investigating, fact-finding that becomes more systematic in its approach, one. Also then a mechanism that collect and record the evidence, and so that really move from information to evidence. Two, and then three is also something that may be progressively doing more of that when it is activated. And I think that that's where the political challenges and pushback against such a mechanism may be possibly appeased by the fact that there will be that standby mechanism, but it doesn't mean that it has a global mandate. It is permanent and it can be activated. And so that may really be more politically feasible. And I think we need to possibly think of this. So maybe more preservation than investigation, and not something that is permanent, not necessarily global. I think that we may have a space to do that. And I think that following the development of the establishment of this mechanism, and as well as UNITAR, that might be the direction in which we can, again, preserve a space, give justice a chance, give criminal accountability a chance, not a guarantee that it is delivered, but at least that it has a chance to exist. And you just mentioned civil society, so just to say that I think that's really crucial. civil society is better equipped. And again, it's not only civil society traditionally, but it's even what I was referring to, citizen investigators. I mean, anyone now with a mobile phone being able to take crucial evidence that no international investigators investigating 3 years after the crime would have, but that would be so crucial if a victim at the time take the crucial photographs. And we will have more and more of that in the coming years, I think.
Myriam?
No, I just wanted to bring to your attention a very peculiar case. You may be aware that in Lebanon, due to the Taif agreement, we have institutionalized the global amnesty. The global amnesty. However, one particular groups of victims, the families of the missing and disappeared, continued relentlessly to demand justice. And something very unique happened for the first and probably the only time I'm aware of. ICRC decided to transfer its records on enforced disappearances to the Committee of the Families of the Disappeared. And that has created an official record, which is in the hands of a civil society organization that is becoming now critical in the surprising enacting of a law after 36 years on a law for the establishment of a commission for the search and identification of the missing and disappeared. Now, that law is based on humanitarian concerns. That was the premise. Even more surprisingly, there is a little article, Article 7, that now appears to open the door to criminal accountability for cases of enforced disappearances. So you see how an official record that was kept by an organization that has, does that for a living, that normally never shares information because of the political sensitivity and maintaining their neutrality, has then arrived to a point where they have transferred part of their records on these specific violations, and now they may, not only they will be the basis for accountability measures, a humanitarian, if you wish, measure that can, however, find and identify some of the remains, and then hopefully the next step will be criminal accountability.
I'm not sure that I share Cécile's optimism about CS. I don't share any optimism about civilian CSOs and their ability to document, and I think this is a big gap in the market. Let me tell you a story about a Rohingya leader in Cox's Bazar. When I turned up there, he hadn't seen any international lawyers, and he was really keen to see international lawyers. He knew about the ICC, or he knew something about it. And as I sat there with him, he wheeled out this tatty book which had hundreds of names of victims in it, rape victims. He'd been lining up rape victims, videoing them, taking their names. It was all in this tatty book. Now, he was doing his best because he didn't have any other options, and he was determined to document, but he had no understanding of how to document in a way which was safe, or which didn't traumatize, or which didn't damage the evidence. And as I understand, one of the complaints of the IIIM for Syria is that they've received hundreds of videos and hundreds of photographs, and much of it is not very useful for future accountability purposes. So if these mechanisms are to be useful, and we have moved from a position where, perhaps in the 90s, professional investigators were working at the ad hocs and so on. We've moved to a situation now where civilians, or CSOs, are now going to do a lot of that work. Then we need to invest some time ensuring that they understand at least the basics of IHL and ICL and the type of standards which are going to preserve that evidence so it is useful in the future. And I'm not convinced, having spoken to many MFAs about this and funders about this, that they are in fact ready to do that. I think they talk tough about accountability. I mean, when I was in Bangladesh, I spent a lot of time visiting all the MFAs, And they were all keen on accountability, but nobody was willing to fund actually documentation, training for the Rohingyas. And frankly, that's the only way that those crimes are going to be properly recorded, is if a sufficient number of those Rohingyas are brought up to a sufficient standard to be able to do it, because the mechanism is not going to be able to do it. So I think states need to put the money where the mouth is and recognize that unless we work with civil society, these mechanisms, for all their faults, are not going to even fulfill their limited mandates.
All right. I'm going to take some questions now from the audience as hands are going up. Okay. I'm going to take about just over 15 minutes of questions. I'm going to claw back a couple of minutes at the end just to wrap up. So if we can start, actually let's start from the back of the room and come forward. If you haven't asked a question, if you have asked a question yet, can we give priority to those who haven't asked a question so far in the conference? Oh.
Hi, thanks for a great panel. I'm Kevin Chang, and I worked and lived in Myanmar in the last 3 years. I moved to Geneva now. And I think, just like Cécile said about the mobile phone for Syria, I think Myanmar is probably one of the first genocides that everybody knew it was going to happen, maybe 10 years before, 5 years before, 1 year before, and surely it happened. And you know, I think it's also one of the cases where there's now, and you know, part of our mission here is to prevent the next how many genocides, is that there was a clear sort of bifurcation in both the diplomatic community and the UN. Bifurcation in the UN is that even the fact-finding mission came out pretty strongly criticizing the UN agencies, UN country team, for refusing to cooperate and sometimes even obstructing. And we heard various sort of claims in the media about the sort of leadership of the UN at the time. And of course that, you know, there was a whole sort of decision to exclude the Rohingya, allowing, you know, $50 million funded census back in 2015 that didn't count the Rohingya population and so on. That was a UN funded thing. So there's that sort of bifurcation, and in that there's one side that deals with human rights and criminal accountability. That's a bureaucratic system, business as usual. On the other hand, we will continue funding related kind of things, such as, you know, this ongoing 20 million euro project. You know, we have colleagues there who are doing capacity support for justice and human rights. But again, that's bifurcated in that you don't talk about the Rohingya, you don't talk about Rakhine, you cannot work there, but then the rationale is that everybody else needs help, and therefore we're there. And also, I sort of give an example of where, you know, I was invited to the Norwegian embassy during the height of the genocide, and they were selling salmon to the increasing middle class of Myanmar. You know, Norwegian salmon's very tasty. So you have this kind of stuff going on, and I just wonder, you know, just to invite some comment firstly on the whole integrity of the international system, that we can allow these things happen. You know, the left arm doing something and the right arm doing something completely different. But also, is there actually some way that if there's clear obstruction by UN officials, could that amount to some kind of accountability for acts or omissions by UN officials? Thanks.
Okay, thank you. We're going to take a couple of questions and then we'll have the panel answer. Yeah, please.
Thank you very much. I'm Olivia Lantermos from the London School of Economics, and I wanted to come back to the question of the link of these mechanisms with transitional justice objective, especially perhaps because in recent decades we've been increasingly talking about the limits of criminal accountability and the importance of broader truth-thinking reparations mechanisms, and perhaps this time with these mechanisms to think less of the limitations in terms of criminal openings, but more about the new opportunities that they have to use to link more with transitional justice mechanism. And I think this is something that the mechanism for Syria is already trying to do with, for instance, missing persons. But I wonder whether there might be a difficulty or challenge in terms of balancing with the need to communicate and reach out to civil society on the one hand, and the importance of confidentiality of these mechanisms, especially, for instance, in the case of Myanmar, where there is no longer a commission of inquiry, and these mechanisms have less of a public mandate or publicly reporting mandate than previously commissions of inquiry. So how do you balance between broader communications and transitional justice on the one hand, and on the other hand, confidentiality imperatives?
Okay. Is there another question from the back? Otherwise, we'll start with those two. Oh, okay. Yeah. Okay, well, let's start with those two, and then we'll go to the next round. So just, who wants to start? You're looking keen, Anna Myriam.
No, on the coordination with transitional justice mechanisms, I perfectly, I see the point. The issue is that transitional justice measures make sense when a context, a country, comes to a critical moment, a crisis, that urge the establishment to pursue a change. Okay, whether genuine, not genuine, but you have a rooted link with the institutions and society on the ground. In Syria and Myanmar, and that was one, the concern I was raising before, beside the possibility to create really an official mechanisms, is the fact that there is really no attempt or even remotely the interest to acknowledge and to implement transitional justice measures that complement criminal accountability. So, I mean, this is the problem. What can we do? We can certainly bring up the voices of the victims. We can help with a variety of different measures, including universal jurisdiction, including any other mechanism, any other process that we are able to tackle, to keep the pressure, the information, the need for everybody to continue and to go, and therefore to provide justice. But at this point in time, honestly, for Syria, the only very slim hope I have is that by continuing involving civil society and victims groups, and the information that we are collecting through the IIIM, maybe this very fragile constitutional review process may be informed by what and how happened. But you realize that given the defeat that we have experienced in the peace process, the hopes are not very high.
I agree, and a small thing to add, if we focus on transitional justice, I think it's very important not to stick merely to accountability, because it shouldn't end there. We should go beyond that, look at the research, look at do research, look at the causes, take away the causes, and support the victims, because that fully package, only then we achieve lasting peace. So it should go beyond the accountability. So,
yeah, and just if I can combine both questions, I think, having expressed such pessimism about accountability, I think the reason I think it's important to express that pessimism is because then we need to look for solutions. What struck me in both Ukraine, where we've been working for many years now, and also in Bangladesh, is the lack of IHL dissemination. In Ukraine, for example, OHCHR and OSCE have the two main monitoring missions. There are no IHL specialists working in those monitoring missions, so their reports are essentially factual, very useful, but they do not inch forward and tell a story about the IHL violations. So their impact in terms of establishing and entrenching IHL norms is deficient, and opportunities are really lost. Back to Cox's Bazar, I'm really struck by UNHCR, one of the lead organizations, IOM, there's Save the Children, there's the World Food Programme, and none of these organizations are working with IHL at their fingertips. So whilst we don't have criminal accountability, why don't we get on with ensuring that our institutions, our international organizations, our UN agencies are properly empowered to disseminate IHL and entrench and build norms, we are not going to have criminal accountability of the kind we want for a generation, if not longer. The way we get it more quickly, in my view, is we ensure that our institutions and our organizations and our NGOs and our amnesties are fully maxed up in terms of IHL and are using it and demanding, I'm going to the gentleman's question, demanding compliance with it and not giving rise to these contradictions where on the one hand there's a genocide next door and on the other hand agencies are not even referring to it. That I think is one of the big problems that we should as an international criminal community be working at while we wait and push for criminal accountability to become something more real.
Okay. Are there other questions in the audience? Toby, Ambassador Rapp.
I guess my question is probably mostly directed at Wayne, with an equal level of pessimism. I think the same, we've experienced difficulties in the context of Syria and the Rohingya with the documentation process. My question is two parts. First, do you think that the problem is the training that has been done has been directed to elements of crime rather than practical skills of documentation? You know, teaching a human rights monitor the elements of war crimes or crimes against humanity is one thing, but actually teaching them how to conduct an investigation, how to collect evidence safely in a secure environment is much more important. That's certainly my experience with a lot of the Syrian groups. The second part is, and you've mentioned a few organizations that are sort of involved with the process, but do you find that those organizations that are conducting the training are not experts themselves, that having a master's in international human rights law, having never stepped into a courtroom, doesn't really equip you to be training people in Syria and Myanmar on how to conduct an investigation? Do you think that's also part of the problem?
Okay, and then I think Ambassador Rapp had, so. Is it, I need a mic somewhere, please.
I'm obliged to ask an optimistic question. Of course, it'll be directed at Wayne. And you know, a lot of ways that we started in this process 20 years ago is I think perhaps a little bit out of date. And I don't want to be too hopeful about technology. I mean, Cécile just talked about the mobile phones, and of course, there's a lot of the 2 million videos out of Syria that are non-usable. But progress has been made now in an open source protocol that's going to be endorsed by the High Commissioner. Then, of course, people need to be trained in how to use it. But this is the essential evidence, for instance, on the MH17 case, which is open source in terms of where that rocket was launched from. It's been very useful in determining the attacks on hospitals and everything else. Mm-hmm. But I wanted to take it just a little further in terms of the obligations of the IAM, because open source is something that obviously we hope they have the ability to deal with. But to a large extent, there can be evidence in the social media that's closed, that's private, and that would require search warrants and that kind of thing. I mean, there's generals who maintain sites that had 1 million users that incited the genocide of the Rohingya. Shouldn't Nick be going to the Department of Justice in Washington and asking for a warrant against Facebook to get the accounts of this general and that general and that general and that general, and presenting the probable cause for it, acting like what we hope these institutions will be, sort of prosecutors that are preparing cases eventually for trial, but prosecutors without yet courts, but with those same kind of authorities. And that if one has the technical proficiency to do this, of course there's other places like with the ISIS phones, everybody in ISIS had a phone. If those can be obtained, and certainly Karim Khan is trying to get to that, and then what he can share it with. But there's relativity media and other things that can be used then to organize the communications in terms of who was ordering whom, where they were moved, et cetera. But there's a massive amount of material that's out there. that could be exploited, but it requires us to, move out of the 20th century and use the tools that are there, and that's a place where there is indeed some optimism, and then being able to connect the dots and to hold high-level perpetrators to account, and of course assist the victims. But of course they're also going to need skills training and how to use the mobile phone and eyewitness and everything else, so their work is valuable. But I do think that, so I want you to respond to that. Don't you think that's perhaps an antidote to this pessimism and the possibility that we may be able, with the right resources and commitment, to make use of these institutions in ways that will develop solid evidence that if eventually justice decides to come, it'll have something to work with.
Leila? Leila, do you have a question? Yeah.
So this must be the optimist corner over here. It seems to me that we're in a situation now where global leadership has failed us, right? The Security Council is completely dysfunctional. The kind of leadership we had in the this is going to be optimistic. The kind of leadership we had in the 1990s just isn't there, right? Even if putting aside the United States, Russia, and China, which aren't going to lead, Britain is in the throes of Brexit, and France and Germany are sort of huddled together for warmth, right? So there's not much we're getting from the global community the way we had in the 90s. So what I see, which is it's like, the way after you have a volcano, all the little shoots of green come up, which is we see civil society jumping in with both feet because the ideas are still powerful. And so whether it's, the last panel didn't even talk about Hussein Habre, which was a fabulous universal jurisdiction case brought in the Global South by the Global South, right? And I do see, our institute has a tiny little project in Bangladesh, but we do go into Cox's Bazar with a team of doctors to do education about international justice. So I do see civil society jumping in. I see the General Assembly jumping in where the Security Council is frozen to create mechanisms. That's not the same as having great leadership from the top down, but the leadership from the bottom up isn't all bad if we can connect to each other and use it. So that was really more of a comment than a question. I think you all sort of spoke to that, but I do think that it is a glimmer of hope in what could otherwise be a very dark night.
All right. If people can make it very short, we've got literally 5 minutes left, and I need to give Wayne this chance to answer. No, go ahead. Well, I don't mind who goes first, please.
Okay, very short. Many of you have spoken about the international investigative mechanisms on this panel. Wayne, I want to take off from one of your comments. Could all of you, or some of you, speak to your experience as to the resource difficulties, in other words, the funding difficulties of these mechanisms, and whether you see any hope for an improvement in the kind of funding that's made available for very costly investigations?
Right, thank you. Jennifer, keep it very short.
Yeah,
so
I'll keep
we're
it
not
really
going to have
short.
time to answer any of these questions.
Promise. Some of you discussed getting the views of victims, and how do you do this without also inadvertently creating unrealistic expectations? So years ago in Afghanistan, a group was going around explaining what is a hybrid, what is an international, they prefer a hybrid or international. And unfortunately, so few situations, is this even possible? So, how do you solicit victim views without falling into this unrealistic promise?
Okay, all right. Wayne, you're going to have to do some we're going to have to do some speed answering, and then I'll get to the rest of the panel since you were named first.
Okay, some very quick answers then. To Toby's question, do I think there's a distinction between elements of crimes versus practical guidance? I think it depends on the user. I mean, what I'm advocating is a much more joined-up approach. So CSOs, documenters probably need much more practical. Organizations like WPF need elements of crime so they can access and leverage access more easily, can communicate with warring parties more easily. I think that fact-finding missions probably need a mixture of both because they need to apply, in my view, a more IHL or ICL approach to their fact-finding missions. So I think it's across the board depending upon the users, and I think that's a real opportunity for us to do some more joined-up thinking on that. Problem of lack of expertise in training. I think CSOs, and I'll go to the professor's question as well. I think CSOs represent a great opportunity. I think, what I'm impressed with my work constantly is how motivated and smart and focused CSOs can be, but they need more support, in my view. They need more support in terms of technical ability to train. In terms of the ambassador's comments, I'd simply say this, that Bellingcat, an open source, fantastic investigation, investigated MH17 and made it crystal clear that that weapon came from Russian stores of ammunition. They tracked it across the country. But at the end of the day, that case will still depend upon whether it was an accident or not. And I think we need to be realistic about what open source investigations can give us. They can give us a lot, but they may not change, in my view, the essential questions of criminal liability. I'll give it to others,
okay.
Yes.
Cécile?
Thank you. So first, on the important question that you asked, Jennifer, I mean, I share your views, and I think I alluded to that. In the challenges of interacting with victims and survivors and raising unrealistic expectations, which may even be, in fact, dangerous expectations because of the context. And I mean, I am very concerned that there may be certain times where we may even put people at risk. And I mean, there was allusion being made to records being kept, with names. And I am not completely sure that many other organizations, and not only very local civil societies, are always absolutely sure of the confidentiality of the information and of all of the risks that victims do take in any case, when they come forward and they expose themselves. And that's the security risk. It's also all of the mental issues that we've not even been discussing. So I think that's a genuine concern and one that we cannot forget. And criminal accountability should never be at the cost of, in fact, the survivors. And so that's what really a victim-centered approach should really be. So it's a very difficult question of squaring the circles. How do we involve victims and at the same time do not put them at risk? On the question of funding, it is probably the key issue. And because we do see, I do see a clear parallel between the decreasing political appetite for criminal accountability and the similarly decreasing amount of funding. And of course, they're connected. And they're connected as long as the funding comes primarily from states, government donors. And that's really how all of the various international criminal jurisdictions have been paid so far and are still being really funded. And that's also how those different mechanisms that we're speaking of are being funded. I believe, though, that that's also through these challenges that we may have to reinvent the systems of at least not accountability in terms of the deliveries of trials, but at least the documentation and preservation that, again, is not the panacea, but is at least something that we can do to continue to keep open the avenues for further criminal accountability at a later stage if it comes. If I may just take 1 minute, because it's also a way of responding to then both Stephen and Laila's questions and my similarly optimistic, probably a bit unrealistic, but views come from something that I think, I mean, I'm taking the risk of not being taken seriously ever again and not being invited here. But I mean, if we project into where we may be when we reconvene here in 2030, okay? We may be having a world in which when we think of international crimes being committed, we in fact have bystanders, citizens, and civil society wonderfully equipped, not only in terms of their knowledge of the elements of the crimes, but also the capacity to really obtain it safely, and via mobile phones that they will not be looking like that, they may even be wired to our brain. But in fact, through this, everyone taking them on as they occur, connect them and put them into a wonderful permanent collection of information that is permanent, that is being kept, and they just upload that information. That permanent one place, you know, I mean, we've heard of eyewitnesses and there are many different systems being established now. They may be consolidated into one single place where the very capable investigators and duly trained to the citizens are all uploaded that information into this. And again, that's why you're not going to take me seriously, but that permanent collection of investigation is mostly run by artificial intelligence that starts screening that information for authentication, that to organize it at least by situation, country per country, but even region per region, types of crimes together, and that's already possible, we know it. And then that permanent collection of information also becomes, you know, filter, organize, analyze in ways where computers, and especially as we're moving towards quantum computing, may be much better able to do than human brains, and that becomes the depository to which any prosecutors, whether a national prosecutor or an international prosecutors, can then go and do the crucial work that Wayne you highlight, which is then the attribution, which of course then cannot be done by those that collect the information. But really, and so I hope it's not too crazy. I think that it's based on in fact, where we can see the world going. I don't think we'll be there in 2030, but that's probably the trajectory in which we could be going, and that will cost far less and be much more efficient.
Right. I think we're about to get our mics cut off. I'm going to close very quickly now, just saying thank you all to panelists. Thank you so much for the questions. If panelists feel like they haven't had the answer to the question, they can collar the person who asked it in the aftermath or on the bus. We had a great discussion around practical implications, around giving a chance for accountability, but there are questions around whether there's a gap as to whether communities, victim and communities are understanding what is actually likely to be delivered, as well as whether there's enough emphasis on other forms of transitional justice, understanding the nuances of the perpetrator community. But part of me also thinks, aside from maybe the future being the future of artificial intelligence, the future of this may not be predicated so much on national jurisdictions, that it may in fact be a future of civil society motivating involvement and bringing of cases forward to find accountability. And I think the final thing we also learned is that both Toby and Wayne probably need a beer bought for them to cheer them up. Thank you, everyone.